Welcome back to Death Row Cases. I want to take a moment for a thank you. I've been working on this podcast for a few weeks now, and I'm genuinely grateful for everyone who's been listening and supporting it. My first goal was to get a video to 100 views in its first week, and I'm happy to say we hit that. My next goal is 500 views in the first week, and for that, I need your help. If you're listening right now, it would mean a lot if you liked, followed, and left a comment. That's genuinely how the algorithm works. The more likes, follows, and comments an episode gets, the more it gets shown to new listeners. It doesn't cost you anything, but it makes a real difference in helping this podcast grow. Thank you again. Today, the case of William Sylvia. On September 22nd, 2006, a family in Seminole County, Florida, was hosting a cookout in their carport. Within a few minutes, one woman was dead, another had lost an eye and part of her nose, and a man who 5 hours earlier had calmly bought a shotgun was driving away in his truck. That man was William Francis Sylvia. On August 18th, 2026, 20 years and 11 months after that evening, the state of Florida is scheduled to execute him. This is his story, built from court records, sentencing orders, and published news coverage. We take no position on guilt beyond what the courts have already established. Let's start with who William Sylvia was before any of this happened, because in this case, the unraveling of an ordinary life is most of the story. William Francis Sylvia Jr. was born in March of 1965. By the time he was in his early 40s, he was working, married, and living what looked from the outside like a normal life in Central Florida. He and a woman named Patricia had married in 2002. Patricia had 2 children from an earlier relationship, a teenage daughter and a younger son. Sylvia became their stepfather. For a few years, that was the shape of the family. Nothing about the public record suggests a childhood of extreme deprivation. Nothing points to a documented history of violence before this case. And unlike some of the men we've covered on this podcast, there's no earlier conviction on file, no outstanding warrant in another state, no pattern the courts had already flagged. That absence matters. It means this wasn't a man with a long rap sheet who finally escalated. It means something changed, specifically inside that marriage, in the months before September of 2006. By the summer of 2006, the marriage was falling apart. Patricia and William separated in July. According to court records, the separation followed an accusation Sylvia made that Patricia had been sexually involved with her own older sons. There's no indication in the public record that this accusation was ever substantiated. What it did do was mark the end of the relationship. Patricia moved out. She took her 2 children, by then 16 and 13, and went to live with her mother and stepfather in Winter Park. Her sister was already staying at that house too. It was, in other words, a household of women and children, with Patricia's mother and stepfather providing a landing place for a daughter leaving a bad marriage. William Sylvia, meanwhile, was coming apart. He lost his apartment. He became homeless, living out of his truck, occasionally paying for a motel room when he had the cash. And more than once in the weeks before the murder, he showed up at the Winter Park house in the middle of the night, unannounced, asking to speak to Patricia. Every time, he was turned away. This is a pattern that shows up again and again in domestic violence homicides, and it's worth naming directly. Repeated, unwanted contact after a partner has left, especially contact that escalates in frequency or shows up at odd hours, is one of the clearest warning signs that risk assessors and advocates look for. It doesn't mean every person who does this will become violent. It does mean that, statistically, this specific behavior, refusal to accept a separation combined with persistent unannounced contact, sits near the top of the list of red flags in intimate partner violence. Researchers who study intimate partner homicide have identified a cluster of factors that tend to show up together in the months before a killing like this one. Separation itself is one of the biggest. It's a common misconception that leaving an abusive or controlling relationship makes a person safer. In a lot of cases, it's actually the opposite, at least in the short term. The period right after a partner leaves is statistically one of the most dangerous windows in the entire relationship, because it's the moment when a controlling partner loses the ability to control anything, and some react to that loss by escalating. Other factors researchers look at include recent job loss, financial strain, access to a firearm, and a partner's refusal to accept that the relationship is over. By September of 2006, William Sylvia had almost every one of those factors present at once. He'd lost his job that same day. He'd already lost his home weeks earlier. He'd been repeatedly turned away when he tried to see Patricia. And on the afternoon that all of it came to a head, he had easy, legal access to a firearm, and he used it within hours of buying it. None of this excuses what happened. It's not offered as an excuse. It's offered because this case, more than some of the older ones we've covered on this podcast, fits almost exactly into a pattern that domestic violence researchers and advocates have been documenting for decades, and that pattern is worth naming precisely because it keeps repeating in different families, in different states, year after year. On September 22nd, 2006, 3 things happened to William Sylvia within a matter of hours. He was fired from his job. He had, by that point, already been sleeping in his truck for weeks, and sometime that afternoon, with what the court record later described as no unusual agitation, no panic, nothing that stood out to the person behind the counter, he walked into a store and bought a Mossberg 500 Persuader, a 12-gauge shotgun. He also stopped at a separate store and bought 4 boxes of shells. Surveillance video from the gun purchase was later entered into evidence. The sentencing order specifically noted that the footage showed no bizarre, agitated, or panicked behavior. He was calm. That detail became legally significant because Florida prosecutors argued it supported premeditation. The idea that this wasn't a sudden loss of control, but a deliberate, planned act carried out by someone who was, by every outward appearance, thinking clearly. That evening, the Woodard family was hosting a cookout in their carport. Patricia was there. Her mother, Betty Woodard, was there. Her stepfather was there. Her sister and her 2 children were there too. It was, by every account, an ordinary family evening, the kind of gathering that happens in backyards across the country on any given weekend. William Sylvia showed up. According to testimony from Patricia's daughter, Silvia and Patricia had a tense conversation, one more round in what had clearly become a long-running conflict. At some point, Patricia walked back inside the house. Silvia went to his truck. Patricia's daughter told authorities that as the conversation ended, she heard Silvia tell her mother that she was going to be sorry. He came back from the truck with a shotgun. He fired 1 round into the air. As the family scattered, trying to get inside, trying to get away, he moved toward Patricia. Her mother, Betty Woodard, put herself between them. Sylvia fired into the carport and into the house. 6 more shots, on top of the one already fired into the air. 1 round hit Betty Woodard in the face. She survived, but she lost her left eye and the top portion of her nose. Another round hit Patricia in the head. She did not survive. In total, Sylvia fired 7 rounds that evening, 1 into the air as a warning or an announcement, 6 more into the carport and into the house itself, where children and other family members were trying to find cover. A 12-gauge shotgun at close range is not a precise weapon. The fact that only 2 people were hit out of a shotgun fired 7 times into an occupied carport during a family gathering is closer to luck than to anything resembling restraint. Sylvia got back in his truck and drove away. He was arrested the following morning in the parking lot of the motel where he'd been renting a room. There's no evidence he was intoxicated at the time of the shooting itself, but by the time officers picked him up hours later, he appeared to be under the influence of something. On the drive to the Seminole County Sheriff's Office, he confessed. He asked the officer transporting him whether the officer was married. Then he said he understood why he'd ended up in this situation, because he was married too. He told police he'd shot Patricia because she had spent all of their money and had started seeing her ex-husband again. That's the confession, in his own words, filtered through the memory of the officer who wrote it down. A husband, recently separated, recently fired, recently homeless, who bought a shotgun on a calm afternoon and used it on his estranged wife and her mother because of money and jealousy. Sylvia went to trial in 2008. He was convicted of first-degree murder for the killing of Patricia Sylvia and of attempted first-degree murder for the shooting of Betty Woodard, who survived but was permanently disfigured. For the attempted murder charge, he received a life sentence. For the murder charge, the case moved into the penalty phase, the part of a Florida capital trial where a jury decides whether to recommend death or life without parole. The jury voted 11-1 in favor of death. Florida law, like most states with capital punishment, requires a court to weigh aggravating factors against mitigating ones before a death sentence can be imposed. Aggravating factors are the elements that make a crime especially severe. Things like whether the murder was committed in a cold, calculated way, whether it happened in front of children, or whether the defendant showed a particular disregard for the safety of others nearby. Mitigating factors are the elements that might argue for leniency, a difficult childhood, a documented mental illness, an absence of any prior criminal record. In Sylvia's case, the sentencing order pointed specifically to the calm, deliberate nature of the gun purchase, captured on that surveillance video, as evidence weighing toward premeditation rather than a sudden loss of control. The fact that the shooting happened in a carport full of family members, including 2 minor children, was also treated as an aggravating circumstance. On the other side of the scale, the record shows no significant criminal history before this case, which is itself sometimes weighed as a mitigating factor, though clearly not one that outweighed the rest here. We've talked before on this podcast about how unusual it is, internationally, for a jury to be able to recommend a death sentence without total agreement. Florida is one of the few American states where that's historically been possible, and the exact threshold has shifted more than once over the years, which is relevant here, because Sylvia's case became a direct example of how much that shifting threshold can matter to an individual defendant. At the time of his trial, an 11-1 vote was more than enough. The judge accepted the recommendation, and Sylvia was formally sentenced to death. It's worth pointing out how much that threshold has moved over the years, because it says something about how much a death sentence in Florida can depend on exactly when a trial happens to take place. In the late 1980s, when we covered an earlier Florida case on this podcast, a bare majority of 7-5 was enough to recommend death. By the time Sylvia was tried in 2008, the requirement had tightened somewhat, but a unanimous vote still wasn't required. Then came Hurst in 2016, which pushed the state toward requiring unanimity. Then, after a 2023 school shooting case in which a jury declined to recommend death without a unanimous vote, the Florida legislature moved the threshold back down again to 8 of 12 jurors. Under that current law, Sylvia's original 11-1 vote would still be more than sufficient today. The rules keep shifting, and depending on which year a person happens to stand trial, the same underlying facts can lead to very different sentencing outcomes. His case went through direct appeal, the standard first round of review that every death sentence in Florida receives. His attorneys raised 6 separate issues related specifically to the penalty phase, the part of the trial that produced the death recommendation. In 2011, the Florida Supreme Court reviewed those arguments and affirmed both the conviction and the sentence. As far as the court was concerned at that point, the case was settled. In 2012, Sylvia did something that would end up mattering enormously later. He waived his right to pursue post-conviction relief. In plain terms, post-conviction proceedings are the next layer of appeals after direct appeal is exhausted, the stage where a defendant can raise claims about new evidence or about problems with the original trial that weren't addressed on direct appeal. By waiving that right, Sylvia was essentially telling the court he didn't want to pursue those further challenges. The Florida Supreme Court reviewed and affirmed that waiver in 2013. At the time, this looked like the end of the legal road. It would turn out to be the single most consequential decision in the entire 20-year history of this case, though not for a reason anyone could have predicted in 2013. In January 2016, the United States Supreme Court decided a case called Hurst versus Florida. We've discussed this ruling before on this podcast because it reshaped death penalty law across the entire state. The court held that Florida's old sentencing scheme, where a judge, not the jury, made the final factual findings needed to impose death, violated a defendant's constitutional right to have a jury decide those facts. Later that year, the Florida Supreme Court applied that ruling and required unanimous jury recommendations going forward, a major change from the non-unanimous system that had convicted men like Sylvia in the first place. For a group of roughly 150 death row inmates whose sentences became final after a related 2002 ruling called Ring versus Arizona, Hurst opened the door to a new penalty phase, a chance to have their case reheard under the new, stricter rules. William Sylvia was one of them. In fact, a circuit court initially agreed and granted him a new penalty phase. The state appealed that decision, and this is where the 2012 waiver came back into play. The Florida Supreme Court ruled that because Sylvia had voluntarily given up his right to post-conviction relief years earlier, he wasn't entitled to Hurst relief either. His own decision to stop fighting in 2012 was used in 2018 as the reason he couldn't benefit from a change in the law he had no way of anticipating. It's worth sitting with that for a second. Sylvia's original jury recommended death 11-1 under a system the U.S. Supreme Court would later say was unconstitutional. Roughly 150 other Florida inmates in a similar position got a second chance at sentencing because of that ruling. Sylvia did not because of a legal waiver he signed years before Hurst even existed. Whether that outcome is fair is exactly the kind of question that death penalty litigation across the country keeps running into. How much should a defendant's earlier legal choices bind them when the rules of the game change afterward in ways nobody could have foreseen? For most of the 2000s, that was where the case sat. Then, in 2025, Florida's pace of executions changed dramatically. The state carried out a record 19 executions that year, more than in any year of the modern era. Governor Ron DeSantis has signed death warrants at a rate far exceeding recent history. And by the time he signed Sylvia's warrant on July 17, 2026, it was already the 13th warrant he'd signed that year alone. To put that pace in perspective, in the weeks surrounding Sylvia's warrant, Florida executed 2 other men on the same day, the first time that had happened in the state in over 60 years. If Sylvia's execution goes forward as scheduled, he will be roughly the 32nd person put to death in Florida in a stretch of less than 2 years. Legal observers have pointed to a combination of factors behind the surge: aging death row populations, the resolution of long pending appeals, and a governor moving through the warrant process more quickly than his recent predecessors. Whatever the underlying causes, the practical effect is that cases which might once have taken decades longer to reach a scheduled execution date are now moving through the system markedly faster. Sylvia is scheduled to die by lethal injection, the standard method in Florida and most other states that still carry out executions. We've discussed the mechanics of Florida's 3-drug protocol in earlier episodes of this podcast, and the state's current combination has itself been the subject of ongoing legal challenges in other cases working their way through the courts this year. As of this recording, no similar procedural challenge has been reported specifically in Sylvia's case. His attorney's remaining arguments center on the sentencing history we just walked through, not on the execution method itself. After the warrant was signed, Sylvia's attorneys filed what's called a successive motion, a new attempt to have his death sentence vacated and the execution stayed. The Florida Supreme Court placed the case on an expedited schedule, instructing every trial judge and attorney involved to move quickly, because the execution date was already fixed. The lower court denied the motion. Sylvia's team appealed that denial too. As of the recording of this episode, that appeal, along with anticipated efforts to bring the case before the U.S. Supreme Court, is still pending. Sylvia's legal team has indicated that litigation is expected to reach the nation's highest court before August 18th. Whether that happens and whether it changes anything is not something we can tell you with certainty because it hasn't happened yet. Outside the courtroom, Sylvia has a spiritual advisor, a pastor who has also served in that role for other Florida death row inmates executed in this same unusually busy stretch. In mid-August, he made a public appeal directly to the governor, asking him to personally witness the execution if he was going to sign the warrant authorizing it. He also said something that's worth repeating because it reflects how invisible these cases can be to the public, even as the state carries out more of them than ever. He pointed out that most people in Florida won't even know this execution happened. It's a fair observation. When a state moves from 1 or 2 executions a year to more than 30 in under 2 years, individual cases stop making headlines the way they once did. A death that would have dominated local news coverage a decade ago now competes with a dozen similar stories from the same few months. That shift in visibility doesn't change the legal or moral weight of any single case, but it does change how much scrutiny each one receives from the public before it happens. The spiritual advisor's appeal to the governor is an argument you hear periodically from opponents of capital punishment, that officials who authorize executions should be willing to witness them carried out. It's not a legal argument, it's a moral one, and it's unlikely to change anything procedurally, but it's part of the broader public conversation that surrounds every scheduled execution in a state carrying out this many of them. An advocacy group opposed to the death penalty has also started a public petition asking the governor and the state's clemency board to commute Sylvia's sentence to life imprisonment. As we've discussed in previous episodes, clemency in Florida is a purely political process separate from the courts, and the governor is under no obligation to explain a decision either way. In the current climate, with the state's clemency board granting relief only rarely, and the governor's office signing warrants at a record pace, petitions like this one function more as a form of public record and moral protest than as a realistic path to a different outcome. There's a version of this story that gets told almost entirely through legal procedure. A waiver in 2012, a Supreme Court ruling in 2016, a reversal in 2018, a warrant in 2026. That version is accurate, and it's the version that determines whether William Sylvia lives or dies. But it leaves out almost everything about who was actually standing in that carport. Patricia Silvia was 39 years old. She had 2 children, still teenagers, who were there that evening. She had a mother who put her own body between her daughter and a loaded shotgun, and a sister who was also in the house when the shooting started. Very little about who Patricia was as a person, beyond her role as a wife, a mother, and eventually a victim, appears anywhere in the public record we were able to review for this episode. That's a pattern we've noted before on this podcast, and it holds again here. The court documents that survive a case like this are built to establish facts about the crime and the defendant, not to preserve a portrait of the person who was killed. So where does that leave this case as of today? A man with no documented criminal history before 2006 lost his job, his home, and his marriage within the same stretch of months, and responded by buying a shotgun and killing his estranged wife in front of her family. A jury that convicted him did so under rules the U.S. Supreme Court would later strike down as unconstitutional. A legal waiver he signed years before that ruling existed is the reason he never got the chance that roughly 150 other Florida inmates received. And a state currently executing people at a pace unmatched in its modern history has scheduled him to die by lethal injection on August 18th, 2026, at Florida State Prison in Rayford. Betty Woodard survived that night in 2006. She lost an eye. Part of her face was permanently altered. And she has lived for 20 years with what happened in her own carport in front of her grandchildren. By stepping in front of her daughter, she likely changed the trajectory of at least one of those shots. And she paid for that with a permanent, visible injury she will carry for the rest of her life. Patricia's 2 children lost their mother when they were 16 and 13 years old. They are adults now, well into their 30s, and they've spent essentially their entire adult lives with this case still open in one court or another. 20 years is long enough for an entire childhood to have passed in the shadow of a single evening. It's long enough for a case to outlive multiple governors, multiple sets of state Supreme Court justices, and an entire body of federal case law that didn't exist when the crime occurred. None of the outcomes still being litigated, whether Silvia is executed on schedule, whether a court intervenes at the last moment, changes what happened to them. That's not a conclusion. Exactly. It's just the fact that sits underneath every legal argument in this case, on both sides of it. This case is a little different from most of what we've covered on this podcast so far. There's no missing body here, no decades-long question about who actually pulled the trigger, no co-defendant pointing blame at his own brother. William Sylvia confessed within hours, and he's never disputed what he did. The legal fight in this case has never really been about guilt. It's been almost entirely about procedure, about which version of Florida's sentencing rules apply to him, about whether a waiver signed years before a landmark ruling should bind a person to an outcome that ruling would otherwise have overturned. That makes it in some ways a cleaner case to look at than some of the others we've told you about. And it also makes it a useful one, because it shows how much of what happens on death row in a state like Florida isn't about innocence or doubt at all. It's about timing, about which year a person's case happened to move through which court, and about legislative decisions made in Tallahassee that have nothing to do with the specific facts of any one killing, but that end up deciding, case by case, who lives and who doesn't. That's the case of William Sylvia.